Hi, my name is Alicia. Welcome to the comprehensive course on the law of civil procedure in a mixed jurisdiction like Seychelles. This course is specifically designed for adult beginners who are interested in gaining a thorough understanding of the subject matter, from the basics to the advanced concepts. In this course, you will embark on a journey to explore the foundations of civil procedure law, with a focus on the unique aspects of a mixed jurisdiction like Seychelles. Through a combination of theoretical knowledge, practical examples, and case studies, you will develop a deep understanding of the principles, procedures, and rules that govern civil litigation in this jurisdiction. In this course, we will cover the following topics. Key ideas. 1. Understanding the fundamentals of civil procedure. Introduction to civil procedure law. Distinction between civil and criminal law. Role of civil courts and the judicial system. 2. Jurisdiction and forum selection. Determining the appropriate forum for legal disputes. Understanding the concept of jurisdiction. Jurisdictional challenges in a mixed jurisdiction like Seychelles. 3. Commencing a civil action. Initiating a civil lawsuit. Pleadings and the importance of clear and concise statements. Jurisdictional and procedural requirements for filing a lawsuit. Parties and pleadings. Identify the parties involved in civil litigation and their respective roles. Study the requirements and guidelines for drafting effective pleadings. 5. Pre-trial procedures. Examine the importance of pre-trial procedures in civil litigation. Learn about discovery, disclosure, and other mechanisms used to gather evidence. 6. Trial process. Gain insights into the trial process, including the presentation of evidence and examination of witnesses. Understand the principles of judicial ethics and legal professionalism. 7. Judgment and remedies. Analyze the criteria for rendering judgments in civil cases. Explore the various remedies available to successful litigants in Seychelles. 8. Appeals and post-trial procedures. Study the procedures and grounds for filing appeals in Seychelles. Investigate the enforcement of judgments and the mechanisms for seeking post-trial relief. 9. Alternative dispute resolution. Explore alternative methods of resolving disputes, such as mediation and arbitration. Understand the advantages and limitations of alternative dispute resolution in Seychelles. 10. Comparative analysis. Compare the civil procedure rules in Seychelles with those in other jurisdictions. Evaluate the strengths and weaknesses of the Seychelles legal system in civil litigation. By the end of this comprehensive course, you will have a deep understanding of the law of civil procedure in a mixed jurisdiction like Seychelles. You will be equipped with the knowledge and skills necessary to navigate the civil litigation process effectively and confidently, whether as a legal professional or an informed citizen. Join us now and embark on a transformative journey into the world of Seychelles civil procedure. In Seychelles, civil procedure, unlike the English legal system, is codified through the Seychelles Code of Civil Procedure. It is my pleasure to guide you through an important aspect of the Seychelles legal system, the commencement of lawsuits. Our focus today will be on sections 22 through 28 of the Seychelles Code of Civil Procedure, with a special emphasis on section 23. Section 22, Jurisdictional Foundations. Let's begin with section 22. This section lays the foundational jurisdictional rule for all civil and commercial suits. It mandates that such matters be brought before the Supreme Court, except where legislation specifies otherwise. Understanding this is crucial, as instituting an action in an incorrect forum can have detrimental effects on the progression and outcome of a case. While not always fatal, incorrect filing can lead to unnecessary delays and costs, and in some instances, may result in the dismissal of the case. Section 23. commencing a lawsuit. Moving to the core of today's lecture, Section 23. This section is explicit. Every suit is instituted by filing a plaint with the court registry. This is the procedural act that sets the legal process in motion. The requirement for a plaint underscores the formal nature of litigation. It is not merely a matter of intent or declaration, but requires a deliberate act of submission to the court's processes. Section 24. The requirement of signature. Section 24 requires the plaint to be signed by the plaintiff's attorney, or by the plaintiff themselves, if they are representing their own interests. The signature attests to the authenticity of the document and the authority of the person presenting it, ensuring accountability within the legal process. Section 25. Documentary multiplicity. According to Section 25, plaintiffs must file sufficient copies of the plaint and notices of documentary evidence, one for each defendant. This ensures that all parties have access to the same information, maintaining the principles of transparency and fairness. Section 26. Registry entries. Upon receiving the plaint, the registrar is tasked with making specific entries in the Civil and Commercial Suits Register, as dictated by Section 26. This includes the parties' names, residences, the nature of the action, and the relief sought. These entries are critical for the administrative tracking and historical record of legal actions. Section 27. The Plaint Note. Section 27 introduces the concept of the plaint note, which is a form of receipt acknowledging the filing of the plaint. This note is integral to the case as it contains information which is unique to the case, such as the names of the parties, the case number, the court number in which the case is going to be heard, and the date the case was filed. These factual information is vital to the parties when it comes to writing legal submissions, as well as the judge when he or she writes the judgment in the case. Most, if not all judgments, start with the date the case was filed, the facts and nature of the case, and the remedies sought by the plaintiff. Most of these important information can be gleaned from the plaint note. That is why the plaint note is important, and should always be kept safe and secure in the client's file, as it would come in handy when you are required to write your legal submissions at the end of the case. We will come to legal submissions later in this lecture. Now let's move on to filing fees. Section 28. Financial prerequisites. Finally, Section 28 addresses the fiscal responsibilities of the plaintiff. It requires the prepayment of filing fees at the registry of the Supreme Court before any proceedings or issuance of process, reinforcing the notion that access to the judicial system comes with certain costs. It is important that you know in which court you should file a particular action, as filing the wrong action in the wrong court may be fatal to your case, although, admittedly, not always, as would be seen by an analysis of the authorities on the subject. In the leading case of Quilindo and others v. Moncherry and others, SCA 29 of 2009, 2012, SCCA 39, the 6th of December 2012, the Court of Appeal was asked to rule, on an appeal from the Supreme Court, on whether the case had been wrongly suited. In other words, the Court of Appeal was being requested to rule in favor of the appellants, as they claimed the respondents had filed a petition instead of a plaint before the Supreme Court, and this was fatal to their case as it was contrary to Article 343 of the Civil Code. Dealing with Ground 3 of the Notice of Appeal, in paragraph 19 of its judgment, the Court of Appeal held that. Finally, the appellants claim that this case is wrong-suited. Counsel contends that an action to prove paternal descent can only be properly instituted by a plaint, whereas in this case it was done by petition. It is trite law that a wrong suit is fatal to a claim. Counsel bases his submission on Article 343, under which this case is brought. An action under this article may be brought. The definition of action according to counsel is that provided for in the definitions section of Section 2 of the Civil Procedure Code. Cause shall include any action, suit, or other original proceedings between a plaintiff and a defendant. From this definition, counsel extracts a circular argument that actions to prove paternal descent must therefore be begun by plaint, since Section 23 of the Civil Procedure Code states, "Every suit shall be instituted by filing a plaint in the registry." 20. On this issue, the learned trial judge Pereira stated and concluded as follows. Stroud's Judicial Dictionary, citing the case of Bradlaugh v. Clark 8. Appeal Cases 353, defines the term action basically as a generic term meaning litigation in a civil court for recovery of individual rights or redress of individual wrong. Hence, proceedings under either Article 321 or 340 of the Civil Code are for declaration of status and not actions or suits to redress grievances or to recover rights, which necessarily should commence by plaint and be opposed by a defense, so that there would be litis contestation. Hence I hold that Article 343 uses the term action in the generic sense, not in the procedural sense as Section 25 of the Code of Civil Procedure, and that hence, the present proceedings initiated by petition and affidavit are not incompetent. 21. We agree with the learned trial judge that the word action in Article 343 should be given its generic definition, but that does not solve the problem of pleadings as dictated by the Civil Procedure Code. There is no specific procedure in any law indicating how affiliation proceedings should be brought. Hence it would appear that the general rule of bringing such an action by plaint under the Civil Procedure Code would apply. In England, however, affiliation proceedings are brought by petition. It would appear the same applies to Canada, as is evident from the authorities submitted by Miss Agley. See for example O'Driscoll v. MacLeod, 1986, 10 BCLR, 2d. 108. It seems to be the same for other common law countries, including the United States. It is easy to see where the confusion arises in Seychelles. The provisions relating to affiliation proceedings in the Seychelles Civil Code are both transplants from a civil law country of France and a common law country, England. The Seychelles Code of Civil Procedure was also transplanted from England, and one would assume that rules in relation to affiliation proceedings would therefore be similar to those in England. That would not seem to be the case. In the case of Medin vs. Vidit Civil Side No. 266, 2004, unreported, Judge Karunakaran, in a ruling in a similar case, stated, "It is a truism that neither the Civil Code nor the Seychelles Code of Civil Procedure contains any explicit provision stipulating the procedure that should be adopted by a party while seeking a declaratory relief in respect of paternal descent under Article 340 of the Civil Code. It could even be perceived as an ambiguity in the statute. In the absence of it, when an ambiguity or silence or defect appears in a statute, a judge cannot simply blame the draftsman or the lawmaker. He must set to work on the constructive task of finding the intention of the legislature, and he must do this not only from the language of the statute, but also from a consideration of the fact that what if the makers of the statute had themselves come across this ambiguity, how they would have cleared it out. The judge must do as they would have done. A judge must not alter the material of which it is woven, but he can and should iron out the creases in the structure of the statute. Approaching this case on hand in that way, I cannot help feeling that if the legislature had known that someone might in future misconceive the procedure and seek a relief under Article 340 by way of an application, the legislature would have certainly expressly stated in the statute itself that such a relief should be sought by way of plaint. In the circumstances, I conclude that a party seeking a declaratory relief in respect of paternal descent under Article 340 of the Civil Code should commence the action by way of plaint. In my view, this is the proper procedure, which must be adopted in all cases of this nature, and failure to follow this procedure meant that the court has no jurisdiction to try the matter. See Choppy vs. Choppy SLR, 1956, page 162. 23. The Choppy case did discuss the anomaly caused by the fact that the Civil Procedure Code enacted in 1920 contained procedures that were altered in subsequent legislation. The best example is the Matrimonial Causes Act, which introduced the process for divorce by petition. That is not the case for affiliation proceedings. Although some English common law concepts were introduced in the Civil Code, corresponding procedural rules were not introduced by the Act or amendment of the Civil Procedure Code. In the case of divorce, where the procedure is clearly laid that actions are commenced by petition, failure to follow this mandatory provision would result in the court having no jurisdiction in the case and the case being dismissed. In the present case, we do not find the matter to be clear-cut. True, the Civil Procedure Code indicates that the matter should be brought by plaint, but it also states that where there are other provisions made in law, Section 22 does not have to be followed. As we have stated, the introduction of English affiliation concepts logically implies English procedural rules. Can we, as a court of equity, viz. Sections 5 and 6 of the Courts Act, Cap. 52, deny the respondents the right to be heard, because they have brought the action by petition instead of a plaint when the procedure for the same is not clear? We think not. In a recent judgment of the Privy Council reacting to the Mauritian case of Too Many and Another v. S. Veerasamy, 2012, JUKPC 13, Lord Brown stated, 21-24. The Board has sought in the past to encourage the courts of Mauritius to be less technical and more flexible in their approach to jurisdictional issues and objections. Let the Board now state as emphatically as it can its clear conclusion on this appeal. In cases like these, where mistakes appear in documentation, in which a particular jurisdiction of the Supreme Court has been involved, those mistakes should be identified and corrected without penalty unless they have genuinely created a problem, as soon as practicable, and the court should proceed without delay to deal with the substantive issues raised before it on the merits. The same analogy can be brought to this case. No prejudice whatsoever was suffered by the appellants by the proceedings being initiated by petition instead of plaint. In fact, the issue was not raised until at the close of the appellant's case. Lord Brown considered these technicalities a blot on the record of Mauritius for the fair administration of justice. We do not need to fall in the same trap. 26. We are of the view that in affiliation proceedings, until and unless procedures and forms of pleadings are clearly indicated, an applicant cannot be denied the right of hearing for want of proper pleadings. For the moment it would appear that either a plaint or a petition is acceptable as proper pleadings by which such action might be commenced. In the circumstances, this appeal is rejected in its entirety with costs to the respondents. In the case of Iliescu v. Petrescu, MC 101, 2019, 2020 SCSC 637, the 15th of October 2020, the respondent filed a plea in limine litis on the 24th of January 2020. The plea in limine litis was based on the following grounds: that the petitioner should have filed the case by plaint in terms of Section 23 of the Seychelles Code of Civil Procedure, and not by petition, an affidavit, and therefore the case fails ab initio for defective procedures. In his ruling on the point of law, Judge Burhan was of the view that filing a petition, an affidavit instead of a plaint was not fatal to the petitioner's case. In paragraph 8 of his ruling, Judge Burhan stated as follows: "It would be pertinent at this stage to refer to the relevant case law of the Seychelles Court of Appeal, which sets the precedent for this court to follow. In the case of Mary Quilindo and Ors v. Sandra Moncherry, supra, a similar argument was taken up where the appellants in the Quilindo case claimed that the case was wrongly suited. It was contended by the appellants in the Quilindo case that the action to prove paternal descent can only be instituted by a plaint and not a petition, as was done by the respondents in the said case. Relying on the Privy Council decision of Too Many and Anna v. Veerasamy, 2012, UKPC 13, which held, the Board has sought in the past to encourage the courts of Mauritius to be less technical and more flexible in their approach to jurisdictional issues and objections. Let the Board now state as emphatically as it can its clear conclusion on this appeal. In cases like these, where mistakes appear in documentation, as which particular jurisdiction of the Supreme Court has been involved. Those mistakes should be identified and corrected without penalty unless they have genuinely created a problem, as soon as practicable, and the court should proceed to deal with the substantive issues raised before it on the merits without delay. Toomey J.A. proceeded to hold that where no prejudice was suffered by the proceedings being initiated by petition, and not by plaint, such technical objections should not affect the fair administration of justice. In paragraph 9 of the ruling, Judge Burhan continued by stating that the findings in the case of Quilindo were also followed by the Seychelles Court of Appeal, in the case of Ablaazov v. Outen, and Ors, SCA 56, 2011, and August 2013, 2015 JSCCA 23, the 28th of August 2015, where Doma J.A. held. We adopt the reasoning that procedure is the handmaid of justice, and should not be made to become the mistress even if many handmaids would aspire to become mistresses. Siegel v. Film Ansalt 2003 SLR J37. Mary Quilindo, Anne Ors v. Sandra Moncherry and Anna SCA 29 of 2009. Toomey and Anna v. Virasamy, a 2012 a UK PC 13. In the Toomey and Anna v. Virasamy, the law lords of the Judicial Committee were of the view that such technicalities raised to shut out litigants from the court system constitute a blot on the administration of justice. This has been made part of the law of Seychelles, as per the decision of Toomey J.A., now Chief Justice. In paragraph 10 of his ruling, Judge Burhan went on to hold that in this instant case too, the respondent has failed to show that the pleadings by way of petition has resulted in any prejudice being caused to the respondent. He has also failed to show that the statutory provisions of the International Business Companies (IBC) Act indicate that any action brought under the IBC Act should be by way of plaint and not by petition. I observe that several sections in the IBC Act refer to the filing of applications in court, which means petition and affidavit. The mere fact that learned counsel for the respondent has brought several actions by way of plaint in the Supreme Court, as set out in his letter addressed to the court dated the 6th of August 2020, does not overrule the aforementioned findings of the Seychelles Court of Appeal that an action by way of petition and affidavit could be accepted by the court and is not fatal to the case if no prejudice is caused to the case of the plaintiff. And at paragraph 11 of his ruling, Judge Burhan decided that, having given due consideration to the aforementioned cases, this court is of the view that the respondent has failed to properly support his plea that the petition should fail for irregularity of form. The respondent has not shown that he is prejudiced by the form of this suit, that is, it being a petition rather than a suit, nor has he shown that the rule in Section 23 of the Seychelles Code of Civil Procedure is non-derogable. In light of the above, this court holds that this plea in limine litis should fail. Conclusion. It is true that the Seychelles Code of Civil Procedure provides for how a case should be commenced and in which court it should be filed. It is also true that in certain circumstances, filing the wrong action in the wrong court can be fatal to the application, which is liable to be summarily dismissed if contested on a point of law. This is particularly so if the other side can show the court that it has been prejudiced by the action being wrongly commenced and not in accordance with the law. However, as has been seen through the cases, the court has been reluctant to dismiss a case purely on the basis that it has been wrongly commenced. The court has been guided by the principle of justice and fairness rather than being guided by legal technicalities and procedural irregularities. Having said that, it is always better to file your case properly, using the correct procedure, and in the right court, than having to face the legal hurdle of having your case challenged on legal technicalities at any stage of the proceedings. This brings us to the end of today's lecture. Do not forget to like and subscribe for more content on this channel. Ciao!